All right, so you're interested in contract law, but maybe don't have an extra semester to squeeze into your schedule for, full-blown law school experience.
It's quite a lot to pack into such a short time.
We get it. No worries. That's why you're here with us for this deep dive.
Think of us as your translators for this legal crash course.
I love that, a legal decoder ring.
We'll be highlighting those key landmarks of contract law.
Exactly. So, listener, get ready for like a fast-paced journey through contract law. We're not going to be bogged down in all the legal jargon.
We're going to make sure that you come away with those practical insights.
Okay, so where do we even begin with something as big as contract law?
Well, every journey needs a starting point, right?
Yeah.
And in contract law, it all begins with those fundamental building blocks: offer, acceptance, and consideration.
Okay, the legal equivalent of ready, set, go. But there's got to be more than just a formality, right?
Absolutely. These elements are the foundation upon which every single valid contract is built.
Okay.
Think of it this way. An offer is like putting a proposal on the table. Acceptance is like saying, I'm in. And then consideration, that's what each party brings to the table, something of value that they're exchanging.
Okay, that makes sense. And our YouTube prof used a really interesting example to illustrate this. Something about chocolate wrappers being contract consideration.
Ah, yes. The Nestle case.
What was the story there?
They had a promotion going on where you could redeem chocolate bar wrappers for records.
Okay.
And they tried to argue the wrappers themselves had no value.
Oh.
But the court disagreed, saying that since Nestle had assigned value to them in the context of the promotion, they formed part of the consideration.
Wow. That's a really clear example of how the law can find value in some pretty unexpected places.
Yeah.
So we've got our offer, acceptance, and consideration, those initial ingredients for a valid contract. But what happens when things get a bit messy? Life throws a curveball, someone wants to back out, or there's pressure involved. How does the law handle those real-world scenarios?
That's where things get really interesting. Contract law recognizes that not all agreements are created equal,
Okay.
and certain elements can actually invalidate a contract.
So not always as simple as you signed it, you're bound by it.
Not necessarily.
But
We're
they're
talking
not-
about concepts like duress, undue influence, misrepresentation. These can all weaken the legal standing of a contract.
Our YouTube source specifically mentioned wives co-signing loans for their husbands, and how banks now have to be really careful about undue influence in those situations.
That's right. And historically, undue influence often centered around traditional relationships of power.
Right.
Husbands and wives, parents and children, even doctors and patients. But today, with the rise of social media influencers, online marketing, sophisticated financial products, the potential for undue influence has expanded dramatically.
That makes total sense. It's not just about those traditional relationships anymore. It's about anyone who might hold a position of influence over another person, whether it's a financial guru with millions of followers or even just a charismatic online personality promoting a product.
Exactly. And speaking of shifting landscapes, we can't forget the elephant in the room, or should I say the algorithm in the app.
Oh, here we go.
The digital age has ushered in a whole new world of contract law.
Right. Online shopping, digital agreements, those terms and conditions we all scroll past without reading.
Exactly.
Yeah.
From e-commerce regulations to online dispute resolution, our source material just scratched the surface of how contract law is adapting to this digital frontier.
So with this complex digital landscape in mind,
Yeah.
what are the essential things our listeners should remember about the basics of contract law? What are those key takeaways from this first part of our deep dive?
Well, I think first and foremost, understanding those core components of a valid contract.
Right.
Offer, acceptance, consideration.
Those are key.
Those are your non-negotiables.
The essential ingredients in our legal recipe.
Precisely. But beyond just those basics, it's crucial to recognize that contracts aren't just these static pieces of paper. They exist in a dynamic world
Of course.
where circumstances change, misunderstandings arise, and sometimes one party doesn't play by the rules.
Right. And that's where things get really interesting. Because knowing how to navigate those what-if scenarios is essential.
Exactly. And one of the most common what-ifs in contract law, unfortunately, is breach of contract, when one party fails to fulfill their end of the bargain.
Right, because signing on the dotted line is one thing, but actually upholding those promises, that's what really matters. So how does the law determine if a breach has actually occurred? Is it a black and white situation?
It's rarely that simple. You see, not all breaches are created equal.
Okay.
Contract law recognizes that there are different levels of severity
Yeah.
when it comes to breaking promises.
So There are shades of gray in the world of contract breaches. I like it. Give us the spectrum.
Think of it this way. There can be minor deviations from the contract
Okay.
that, while technically breaches, might not significantly impact the overall agreement.
Right.
Then on the other end of the spectrum, you have major breaches
Ah.
that strike at the heart of the contract,
Yeah.
potentially undermining the entire purpose of the agreement.
So using a real-world example, it's the difference between like a contractor delivering materials a day late
Exactly.
versus never showing up to start the project at all.
Exactly. And the consequences of a breach, what the innocent party can actually do about it, often hinge on the nature and severity of that breach.
So how does the law differentiate between those minor hiccups and those major deal breakers?
It all boils down to understanding how different contract terms are categorized.
Right.
Our YouTube lecture focused on 3 main categories: warranties, conditions, and innominate terms.
Yeah.
These classifications help determine the legal weight assigned to different promises within a contract.
Okay, I'm ready. Let's unpack those categories.
Yeah.
What's the difference between a warranty and a condition?
Think of a condition as a fundamental term of the contract,
Okay.
something that goes to the very heart of the agreement.
Right.
Breaching a condition is a big deal. It gives the innocent party the right to terminate the contract entirely.
So if I hire a band to play at my wedding
Okay.
and they show up like 4 hours late after the ceremony is over and all the guests have gone home,
Yeah,
that's a breach of a condition.
you got it. Their timely arrival was likely a fundamental aspect of the agreement, and their breach undermined the very purpose of the contract.
Okay.
Now, a warranty, on the other hand, is a less vital term. A promise that, while important, doesn't strike at the heart of the agreement.
Okay.
Breaching a warranty might entitle the innocent party to compensation, but it doesn't automatically give them the right to terminate the whole thing.
So if the band in my wedding example shows up on time and plays beautifully, but they forgot to play my special request song,
Right.
that's more of a warranty issue.
You've got it. It's a breach, but not one that fundamentally disrupts the entire agreement.
Right. They still did their job, essentially.
They fulfilled the essence of their obligation, providing music for the reception.
Okay, that makes sense. So we've got those 2 distinct categories, conditions and warranties. But then our YouTube source threw a curveball, something called innominate terms. What are those all about?
Innominate terms are the wild cards of the contract world.
Okay.
They don't fit neatly into the condition or warranty box.
Right.
Their consequences depend on the actual impact of the breach, how significantly it disrupts the overall agreement.
Okay, I'm intrigued. Give us a scenario where we'd be dealing with an innominate term.
Let's say you order a custom-made birthday cake for your child's party,
Okay.
and the contract specifies that the cake should be blue and white.
Okay.
However, the baker mixes up the order and delivers a pink and green cake.
Oh, no. Every parent's worst nightmare.
Yeah.
So is that a breach of a condition, a warranty, or are we in innominate territory?
It depends. If having a blue and white cake was absolutely essential, maybe it was meant to match a specific theme, and the wrong colors clash horribly, a court might consider it a breach of a condition.
Yeah.
You could argue that the baker failed to meet a fundamental aspect of the agreement.
Right.
If the colors, while not ideal, aren't a deal breaker,
Right.
it might be considered a less severe breach.
Okay, so it's all about context.
It all boils down to the context
Yeah.
and the actual impact of the breach.
Right.
Did it substantially deprive the innocent party of the benefit they were expecting from the contract? That's the question a court would ask.
So it's not just about ticking boxes. It's about looking at the real-world consequences of a breach.
Precisely.
Hmm.
Contract law isn't just about rigid rules. It's about finding practical and fair solutions in a complex world.
Right.
And speaking of navigating complexity, we can't forget about anticipatory breach.
Anticipatory breach.
Yeah.
It sounds ominous, like one party is making a preemptive strike in the contract game.
It can certainly feel that way. Anticipatory breach is when one party essentially announces ahead of time that they're not going to fulfill their contractual obligation.
Oh, wow.
They're throwing in the towel before the match even begins.
So give us a scenario where this might play out.
Imagine you've hired a famous chef to cater your company's annual gala, a big event with hundreds of guests.
Okay.
But a week before the event, they call and say, "We've overbooked, we can't make it."
Oh, no.
That's an anticipatory breach.
Yeah.
They're letting you know in advance that they're not going to honor the agreement.
Wow. Talk about leaving you in a bind. So in that situation, what are your options? Are you just stuck waiting for them to officially bail on the contract?
Not at all. You have choices.
Okay, good.
You can accept their repudiation, their clear intention not to perform, and treat it as a breach right then and there.
So you're not obligated to wait around and see if they'll change their mind.
Exactly. You can cut your losses, find another caterer, and sue for damages if necessary.
So one option is to walk away. But what if you still want to try and salvage the agreement? Is there a way to hold the other party to the contract, even if they've indicated they want out?
You can attempt to affirm the contract,
Okay.
essentially saying, I'm holding you to this, but this path comes with caveats.
Okay, so you can't just force someone to perform if they're dead set against it. What are the limitations?
Well, for starters, you can't affirm a contract if fulfilling the agreement requires the other party's cooperation.
Right.
And they've made it clear they're not cooperating.
Okay.
You can't, for instance, force that chef to cater your event if they've said they won't do it.
Right.
You also can't put yourself in a position where you're piling on unreasonable expenses
Right.
just to hold them to the contract.
So in our chef example, if I insisted on affirming the contract, knowing they weren't going to show, and I booked the most expensive replacement caterer at the last minute,
Yeah.
I couldn't then turn around and sue the original chef for those exorbitant costs.
Exactly. There has to be a practical and reasonable element to affirming a contract.
It's about making strategic decisions in the face of a breach, not about stubbornly clinging to an agreement that's clearly gone off the rails.
Precisely. And this brings us to another crucial aspect of breach of contract: remedies.
Okay.
What can the innocent party actually do about it? What recourse do they have when a contract goes sour?
Right, because knowing your rights is one thing, but actually having the legal tools to enforce those rights is what truly matters.
Absolutely. And that's where the concept of remedies takes center stage.
Okay.
When a contract is breached, the law offers a toolbox of options
Right.
to try and make things right for the innocent party.
Okay, so let's crack open that legal toolbox. What are some of the remedies available in contract law?
Well, the most common remedy, the go-to solution in many contract disputes, is damages, essentially a financial compensation.
So if someone breaks a promise that costs me money, damages are about making me whole again financially.
You've got it. The goal is to put the innocent party back in the position they would have been in if the contract had been performed as promised.
So it's like hitting the rewind button on the financial consequences of the breach.
Exactly. However, there are limits on what damages can be claimed.
Okay.
It's not just a free-for-all.
Right.
Our YouTube source highlighted two key limitations: causation and remoteness.
Okay, so causation seems fairly straightforward.
Yeah.
You have to prove that the breach directly caused the losses you're claiming. But what about remoteness? What does that entail?
Remoteness is about drawing a line in the sand.
Okay.
It's about determining how far the ripple effects of a breach should extend in terms of liability.
Yeah.
Not all losses that flow from a breach are compensable.
So it's about being fair to both sides. The innocent party deserves compensation for the genuine harm caused by the breach, but the breaching party shouldn't be held responsible for every hypothetical scenario under the sun.
Precisely. And one of the most famous cases in contract law history, Hadley v. Baxendale, established a key test for remoteness that's still relevant today.
Okay, tell us more about Hadley v. Baxendale. What's the story there, and how did it shape the law?
It's a 19th century case involving a broken mill shaft, a vital component of a mill's operation.
Okay.
The mill owners hired a courier to transport the broken shaft to be repaired.
Okay.
However, the courier delayed the delivery, causing the mill to shut down for much longer than anticipated.
Wow.
The mill owners sued for the profits they lost during that extended downtime.
So they were claiming that the courier's delay cost them a significant amount of money in lost business.
Exactly. However, the court ruled that the courier wasn't liable for those lost profits because they were too far removed from the actual breach.
So even though the courier's delay triggered a chain of events that led to financial losses for the mill owners, the court drew a line in the sand.
Precisely. The case established that a breaching party is generally liable for losses that arise naturally from the breach,
Okay.
those that a reasonable person could foresee.
Right.
They're also liable for losses that were specifically contemplated by both parties at the time the contract was formed.
So in the mill shaft case, if the mill owners had told the courier, look, we absolutely need this shaft back ASAP. Our entire business depends on it. Any delay will cost us a fortune in lost profits. Right. Then the outcome might have been different.
Exactly. If they had specifically made the courier aware of those potential losses, and the courier had agreed to be liable, then those losses might have been considered foreseeable and therefore compensable.
So it's about communication, transparency, and making sure everyone is on the same page about the potential consequences of a breach.
Absolutely. Now, another essential aspect of damages is the concept of mitigation.
Mitigation, it's about damage control, right?
Exactly.
Yeah.
Mitigation means that the innocent party can't just sit back and watch the losses pile up.
Right.
They have a duty to take reasonable steps to minimize their damages.
Okay, so give us a scenario where mitigation comes into play.
Let's say you hire a painter to repaint your house, and they breach the contract.
Go ahead.
They start the job, but then abandon it halfway through, leaving your house a patchwork of colors.
Oh no, every homeowner's nightmare. So what's the mitigation angle here?
Well, you can't just leave your house half-painted indefinitely and then sue the original painter for the full cost of repainting it, plus any emotional distress you might have endured living in a construction zone.
Right, so I can't milk this situation for all it's worth.
Not quite. You have a duty to mitigate your losses.
Okay.
This means you'd be expected to take reasonable steps to find a replacement painter to finish the job.
So it's about being proactive and trying to salvage the situation rather than letting the damages spiral out of control.
Precisely. Mitigation is about acting reasonably in the face of a breach to minimize the overall harm.
Okay.
Now, beyond causation, remoteness, and mitigation, there are different ways to actually calculate damages,
Okay.
to put a price tag on the consequences of a breach.
Okay, let's talk numbers. How does the law determine exactly how much money should change hands to compensate for a broken promise?
Our YouTube source focused on 3 main approaches to calculating damages.
Okay.
Expectation loss,
Okay.
reliance loss,
Okay.
and restitution.
All right, let's break them down. What's the deal with expectation loss?
Expectation loss is all about putting the innocent party in the position they would have been in had the contract been fully performed.
Oh.
It's about fulfilling their expectations.
So it's about looking into the future. If everything had gone according to plan, where would the innocent party be financially?
Precisely. Let's say you hire a contractor to build an extension on your house, and they breach the contract.
Okay.
They disappear with your deposit and never come back. Expectation loss would aim to compensate you for the cost of hiring a new contractor to finish the project.
Okay.
Any increase in price due to the delay,
Right.
and potentially even the loss of rental income if you were planning to rent out the extension.
So it's about making sure that, financially speaking, you're no worse off because of the breach.
Exactly. Now, reliance loss takes a different approach.
Okay.
Instead of gazing into the crystal ball of what might have been,
Okay.
it focuses on the past,
Okay.
on any expenses the innocent party incurred
Right.
based on their reliance on the contract.
So it's about compensating them for what they've already lost,
Exactly.
rather than what they might have gained in the future.
Precisely. Let's say you're organizing a big conference, and you hire a marketing firm to handle all the publicity. You pay them a hefty upfront fee, but they fail to deliver.
Oh, no.
No website, no brochures, no social media campaign. Reliance loss would aim to compensate you for that upfront fee,
Okay.
the money you spent in reliance on their promise to perform.
So even if you can't prove exactly how much profit you would have made from the conference if they had done their job, you can at least recoup those initial expenses.
Exactly. Now, the final approach, restitution, is a bit different.
Okay.
It's not about putting the innocent party back in the position they would have been in if the contract had been performed.
Right.
Nor is it about compensating them for their reliance losses.
Right.
Restitution is about preventing unjust enrichment.
Unjust enrichment. Sounds a bit like a Robin Hood scenario.
Well, it's about making sure that the breaching party doesn't unfairly benefit from their own wrongdoing.
Right. Okay.
It aims to return any benefit the breaching party received to the innocent party.
Okay, so give us a scenario where restitution would be the appropriate remedy.
Imagine you paid a contractor a 50% deposit to renovate your bathroom.
Okay.
They start the demolition, a very messy and disruptive process.
Yeah.
But then they vanish, leaving your bathroom in ruins and your deposit in their pocket.
That's rough. So restitution would require them to return the deposit, that money they unjustly gained by starting a project they never finished.
Precisely. It's about making sure the playing field is level.
Yeah.
Even if the game was cut short.
I like it. So we've got these different ways to calculate damages, but I'm curious, are there situations where the usual financial remedies just don't seem like enough? What if a breach of contract leads to something more intangible, like harm to someone's reputation or emotional distress? Can you put a price tag on those kinds of losses?
That's a great question, and it takes us into the complex realm of non-pecuniary damages.
Okay.
Those losses that aren't easily quantifiable in monetary terms.
Right, because sometimes a broken promise can have repercussions that go beyond the financial.
Absolutely. Traditionally, contract law has been hesitant to award damages for things like emotional distress, reputational harm, or loss of enjoyment.
Right.
The focus has been on those tangible economic losses.
So it's been all about the cold, hard cash. No room for feelings in the courtroom.
It's not always that black and white. While financial compensation is the primary remedy in contract law, there are exceptions.
Okay, I'm intrigued. When might a court be willing to venture beyond the realm of pure financial loss and award damages for those less tangible harms?
One well-established exception is when the very purpose of the contract was to provide enjoyment, peace of mind, or some other non-pecuniary benefit.
So if I book a luxury vacation, 5-star hotel, private beach, the works, and it turns out to be a complete disaster, the hotel is a construction site, the private beach is overrun by seaweed, and the gourmet meals are inedible,
Right.
I might have a claim for more than just the cost of the trip.
Exactly, because the very purpose of that contract,
Right.
the thing you were paying for,
Yeah.
was enjoyment and relaxation.
Yeah.
The breach deprived you of that intangible benefit.
Makes sense.
And financial compensation alone wouldn't fully address the harm caused.
Makes sense. But what about those situations where the contract isn't explicitly about enjoyment or relaxation, but a breach still leads to significant emotional distress?
Those cases are trickier, but not impossible.
Okay.
While it's rare, courts have, in exceptional circumstances, awarded damages for distress caused by a breach of contract,
Yeah.
even in more commercial contexts.
Really? What kind of exceptional circumstances are we talking about? Give us an example where the court said, okay, this breach goes beyond the financial, there's real emotional harm here.
Our YouTube source mentioned a case involving a couple who hired a contractor to build their dream home.
Okay.
However, the project was riddled with problems.
Uh-oh.
Shoddy workmanship, missed deadlines, cost overruns.
I can only imagine.
It turned into a nightmare that caused them immense stress and anxiety.
I can only imagine. Building a house is stressful enough, even without those kinds of complications.
Exactly. And in that case, the court recognized that the couple's distress wasn't just about financial loss.
Right.
It was about the emotional toll of having their dreams shattered and their lives turned upside down by the contractor's breach.
So even in the traditionally rigid world of contract law, there's room for compassion and a recognition that sometimes a broken promise can have deep emotional consequences.
Absolutely. Now, while damages are the most common remedy in contract law,
Yeah.
there are other tools in the legal toolbox that we should explore.
Okay, give us the inside scoop on these alternative remedies. What else can the innocent party do when a contract goes south?
One such remedy is specific performance,
Okay.
which is essentially a court order requiring the breaching party to actually fulfill their contractual obligations.
So instead of just getting money, you could actually force the other party to do what they promised in the first place.
In theory, yes,
Okay.
but specific performance is typically only ordered in specific circumstances,
Right.
where damages wouldn't be an adequate remedy.
So give us a scenario where a court might say, okay, money isn't enough here. You need to actually fulfill your end of the bargain.
Imagine you enter into a contract to purchase a rare antique, a one-of-a-kind piece with historical significance.
Okay.
However, the seller has a change of heart and backs out of the deal, offering to refund your money.
Okay.
In this case, simply getting your money back wouldn't truly make you whole.
Right, because you're not just losing money. You're losing the opportunity to own a unique and irreplaceable piece of history.
Exactly, and that's where specific performance might come in.
Okay.
A court could order the seller to honor the original agreement and hand over the antique.
So specific performance is about recognizing that sometimes the true value of a contract lies in something more than just money. It's about holding people to their promises when those promises involve something unique or irreplaceable.
Precisely. Now, another remedy available in contract law is an injunction,
Okay.
which is a court order that prohibits a party from doing something.
So instead of forcing someone to do something, like in specific performance, an injunction is about preventing them from taking a specific action.
You got it. Injunctions are often used to enforce non-compete clauses in employment contracts.
Okay, so if I have a contract with you,
Mm-hmm.
and it includes a non-compete clause that says you can't go work for my competitor for 2 years after leaving my company,
Right?
and you try to jump ship to a rival firm,
Yeah.
I could seek an injunction to prevent you from doing so.
Exactly. The court could issue an injunction prohibiting you from working for that competitor during the agreed-upon time frame.
So injunctions are about maintaining a level playing field and upholding the agreements that businesses make to protect their interests.
Precisely. Now, let's shift our focus from remedies,
Okay.
those tools used to address breaches of contract,
Nope.
to a broader concept.
Okay.
Those situations where a contract might be deemed illegal or unenforceable right from the start.
Oh.
We're talking about contracts that the law just won't uphold no matter what.
Okay, so we're going beyond just individual breaches and looking at contracts that are fundamentally flawed from the get-go. Contracts that the law views as void or against public policy.
Exactly. And there's a wide range of reasons why a contract might fall into this category.
Okay.
Sometimes it's fairly straightforward. Contracts to commit crimes,
Right.
like agreements to sell drugs or engage in fraud,
Of course.
are obviously illegal and unenforceable.
Okay, that makes sense. A contract to rob a bank isn't exactly going to hold up in court.
Precisely. But things get more nuanced when we talk about contracts that are unenforceable for being contrary to public policy.
So what we're talking about are contracts that might seem valid on their face,
Right.
but that contain elements that the law finds distasteful or harmful to society as a whole.
You've got it. It's where the law draws a line in the sand saying, even though this agreement might technically tick all the boxes of a valid contract, we're not going to enforce it because it goes against our fundamental values.
Okay, so give us some examples. What kinds of contracts might be deemed contrary to public policy?
One common example is contracts in restraint of trade,
Okay.
agreements that restrict someone's freedom to work or do business.
So it's about protecting people's ability to earn a living and participate in the marketplace.
Exactly. Imagine you're a talented chef and you sign a contract with a restaurant that includes a non-compete clause so broad that it prevents you from working as a chef anywhere in the country for 10 years after you leave that restaurant.
Wow, talk about a career killer. That seems incredibly unfair.
Exactly. And a
Yeah.
court would likely agree,
Yeah.
while reasonable non-compete clauses can be enforceable
Right?
to protect a business's legitimate interests,
Yeah,
like preventing you from taking their trade secrets to a competitor right across the street.
right.
Overly broad restrictions that stifle competition and prevent people from earning a living are generally unenforceable.
So it's about striking a balance,
Exactly.
protecting businesses,
Right.
but also safeguarding individuals' rights to work and contribute to society.
Precisely. And that same principle applies to other types of contracts that might be deemed contrary to public policy.
Like what? Give us some more examples of these agreements that might raise red flags for the courts.
Contracts that are unconscionable,
Okay?
meaning they are so one-sided or unfair that they shock the conscience of the court,
Wow.
can also be unenforceable. Think about contracts that exploit vulnerable individuals, like those with limited education or who don't speak the language of the agreement,
Right.
by burying unfair terms in the fine print or using deceptive practices.
So even though someone might technically agree to those terms, the court might step in and say, no, this is just wrong. We're not going to enforce it.
You've got it. The law recognizes that not all agreements, even if technically valid, deserve to be upheld.
It's about ensuring a level of fairness and preventing exploitation in contractual relationships.
Now, our deep dive into contract law wouldn't be complete without considering the human element,
Right.
those individuals who are entering into these agreements.
Right, because corporations enter into contracts all the time, but they're not exactly people, are they? So how does the law handle their capacity to contract?
That's a great question, and it touches on a fundamental concept in corporate law. The idea that a corporation is a separate legal entity.
So it's like a corporation has its own legal personality,
Precisely.
separate from the humans who own and run it?
Precisely. It can enter into contracts, sue and be sued, and own property, all in its own name.
Right, okay.
But as you pointed out, corporations can't physically sign documents or make decisions in a tangible sense.
Right, they need a human to do it for them.
They act through humans,
Right,
often they're directors or officers.
makes sense. So what happens if someone acting on behalf of a corporation enters into a contract that's outside the scope of their authority?
That's where things can get tricky, and it's a question of what's called corporate capacity.
Okay.
Historically, if a corporation acted beyond its powers as defined in its governing documents,
The contract could be deemed ultra vires,
okay,
meaning beyond its powers.
so the contract could be invalidated just like that. That seems like a big risk for businesses to take.
It was a significant concern in the past,
Yeah,
but the law has evolved
okay,
to provide more flexibility and protection for those dealing with corporations.
okay. Tell us more about that. How has the law changed to address this issue of corporate capacity?
Modern corporate law statutes generally provide that a company has the legal capacity to enter into any contract that a natural person could.
Okay.
However, this doesn't mean it's a free-for-all.
Right.
There are safeguards in place to prevent abuse.
So what kind of safeguards are we talking about? How does the law ensure that corporations, acting through their human representatives, aren't just running around making agreements they can't keep? Well, directors of companies still have a legal duty to act in the best interests of the company
Right.
and to act within their powers as defined by the company's constitution.
Hmm.
If they enter into contracts recklessly or for improper purposes, they can be held personally liable for any losses.
So it's about accountability.
Yeah.
The law recognizes that businesses need flexibility to operate in a complex world,
Exactly.
but that flexibility shouldn't come at the expense of ethical and responsible conduct.
Exactly. And this move towards broader corporate capacity reflects that reality.
Right.
Now, let's shift gears a bit and consider the situations where external forces, those
Okay.
completely unforeseen events,
Yeah.
can derail even the most carefully crafted contract.
We're talking about those acts of God scenarios, those unexpected curveballs that life throws our way, like
Sure.
natural disasters or pandemics, that completely upend our plans.
Precisely.
Yeah.
And in the legal world, we call it frustration.
Right.
It's a legal principle that deals with those situations where after a contract is made,
Yeah.
something unexpected and outside the control of the parties happens.
Okay.
That makes it impossible or radically different to perform the contract as originally intended.
Okay, so give us a classic example. What kind of unforeseen event would qualify as frustration?
Imagine you're organizing a massive music festival.
You've booked the headliners, secured the permits, sold thousands of tickets.
Right.
But a week before the festival, a hurricane tears through the area, flooding the venue and causing widespread damage.
That's every festival organizer's nightmare. So in that scenario, even though no one is at fault, the contract to hold the festival at that specific venue at that specific time has essentially become impossible to perform.
Right, it's a washout.
Exactly. Now, for a contract to be frustrated, the event must be truly unforeseen,
Okay.
something that the parties couldn't have reasonably anticipated or controlled.
Right, you'd think festival organizers would factor the weather into their plans, especially in hurricane-prone areas. So in those cases, it's more about taking precautions and allocating risks, not about claiming frustration later on.
Exactly. And when a contract is deemed frustrated, it's automatically discharged.
Discharge. It
Yeah.
sounds a bit like those sci-fi movies where they fire up the laser cannons. Is it the legal equivalent of obliterating the contract?
Well, it's not quite as dramatic as that, but it does mean the contract is treated as if it never existed from that point forward.
Okay.
Both parties are released from their obligations.
Okay, so it's like hitting the reset button on the agreement, but what happens if one party has already incurred expenses or performed part of their obligations before the frustrating event? That seems a bit unfair, like someone could get left holding the bag.
That's a valid concern, and it's where the law of restitution comes in.
Okay,
It aims to prevent unjust enrichment,
right.
ensuring that any benefits conferred before the frustrating event are returned or compensated for.
So if our music festival organizer had already paid the venue a hefty deposit for the use of the space, and then the hurricane hit, they'd get their deposit back.
Precisely. The venue wouldn't be entitled to keep that deposit because they weren't able to provide the agreed-upon service due to an unforeseen event.
Okay.
And on the flip side, if the venue had already incurred expenses in preparation for the festival, like hiring security personnel or setting up the stage,
Right.
they might be able to recover those costs from the organizer up to the amount of any benefit they received.
So it's about finding a fair balance, acknowledging that the contract is dead, but also making sure that no one walks away with an unfair advantage because of the frustrating event.
Exactly. It's a way of unwinding the agreement as fairly as possible given the unexpected circumstances.
Right. Okay.
Now, this whole idea of frustration, those unforeseen events that can derail a contract, reminds me of another intriguing aspect of contract law that our YouTube lecturer touched upon: quasi-contract.
Quasi-contract. It sounds a bit like a legal oxymoron, like a contract that doesn't want to admit it's a contract.
Well, it's not quite that contradictory,
Okay.
but it does involve those situations where a formal contract might not exist in the traditional sense.
Okay.
You know, with those key ingredients of offer, acceptance, and consideration.
Right.
But the law still steps in to impose obligations and ensure fairness.
Okay, I'm intrigued. When might this quasi-contract concept come into play?
One classic scenario is what's called quantum meruit.
Okay.
a Latin phrase.
Of course it's Latin. But what does it mean in plain English in the context of contract law?
That essentially means as much as he deserves.
Okay.
Imagine you hire a contractor to do some work on your property, maybe build a fence, renovate your patio, but you don't have a formal written contract.
Yeah.
Just a verbal agreement about the scope of the work and the price.
Okay.
The contractor starts the job, does a significant portion of it, but then you have a disagreement.
Right.
And they walk off the project before it's finished.
That sounds like a recipe for disaster, unfinished projects, disputes over payment, potential lawsuits.
It certainly can be.
Yeah.
But even in those messy situations where a formal contract might not exist,
Right.
the law recognizes that it's not fair for one party to reap the benefits of another party's work without providing reasonable compensation.
That seems only fair.
Yeah.
So how does quantum merit come into play in our contractor scenario?
Even though there's no written contract, the contractor can still sue under the principle of quantum merit
Okay.
to recover the reasonable value of the work they performed before the project went sideways.
So even though they didn't complete the entire project, the law recognizes that they deserve to be paid for the value they did provide.
Exactly. It's about preventing one party from getting unjustly enriched at the expense of the other.
Right. So even in the absence of a formal contract, the law can step in with those principles of fairness and equity to ensure a just outcome.
Precisely. Quasi-contract is a reminder that the law isn't just about enforcing those black and white agreements. It's also about finding equitable solutions in those gray areas where a rigid application of the rules might lead to an unfair result.
It's about making sure that the law keeps pace with the realities of how business is done in the real world, sometimes with a handshake and a verbal agreement, not always with a stack of legal documents.
Exactly. And with that in mind, I think we've journeyed quite extensively through the fascinating and at times perplexing world of contract law.
We've covered a lot of ground today. From those foundational elements of offer, acceptance, and consideration,
Right.
to those complex concepts like frustration and remedies and quasi-contract.
Absolutely.
We've explored the potential pitfalls that can derail even the most carefully crafted agreement and the legal tools available to address breaches of contract.
We've delved into the nuances of contract terms, the distinctions between conditions, warranties, and those enigmatic innominate terms.
Right.
And we've even ventured into the ethical considerations that underpin these agreements.
It's been quite a ride. And while we've explored a lot, it's important to remember, listener, that this deep dive is just a starting point.
Absolutely.
Contract law is a vast and ever-evolving field.
What we've provided today is a framework, a set of guideposts to help you navigate the often complex terrain of contractual agreements.
Exactly. So if something piqued your interest today, whether it's those quirky cases, those fundamental principles, or those intriguing legal loopholes, don't hesitate to explore further.
There's a wealth of information out there.
There really is.
Legal textbooks, academic journals, online resources.
And even more to be learned through real-world experience.
Absolutely.
Because in the world of contracts, as in life, knowledge is power.
Well said.
And on that note, we'll wrap up this deep dive into contract law. We hope you found it enlightening, engaging, and maybe even a little bit entertaining. Until next time, happy contracting.